Hello everyone, welcome to my YouTube channel. In this video, we will look at habeas corpus. This is important because this is a right that protects people against unlawful imprisonment by ensuring people are not detained indefinitely without charge and serves as a critical safeguard against government overreach. We are going to look into its origins and how emergencies can affect it. Let's begin with its origins. In the previous video, we talked about freedom of speech as a right. In addition to this right, the framers needed to figure out what other rights needed to be included in the Constitution. They mentioned that in England, people had the right to habeas corpus, which is Latin for "you have the body." Habeas corpus is a court order that guarantees an imprisoned person the right to produce the great writ, which directs the court to either explain why the government has the power to hold the person in jail, or if it cannot, then to release them. The framers believed unjustified imprisonment was a fatal evil. In terms of exceptions, rebellion or invasion would justify suspending it. Nearly the end of their work, the framers agreed to incorporate habeas corpus with this exception into the Constitution. The first Congress then passed a law giving U.S. courts the power to issue writs or court orders to enforce this. The courts can demand that the government justify detentions, and if it cannot, then demand the release of the prisoner. But how would this right be protected? The Fifth Amendment guarantees individuals the right to protect themselves through a legal process, such as by making their case in a court of law. This is called due process. The 14th Amendment does the same about state governments, but in times of rebellion or invasion, the government does not necessarily have to follow these rules. During times of crisis, the writ of habeas corpus can be suspended and suspects can be kept in jail indefinitely without any explanation why. Under a circumstance like civil war, public safety may require it, which is why Abraham Lincoln suspended habeas corpus. Let's talk more about this. When John Merryman, a farmer and militiaman from Maryland, was accused of destroying infrastructure to prevent Union soldiers from defending Washington, D.C., he was arrested and imprisoned without the option of the Great Writ. Many from both the North and South objected to this suspension, saying that only Congress could take this action. But the Constitution itself is silent as to which or who is to exercise the power. Abraham Lincoln thought the man who, for the time, the people have under the Constitution made the commander-in-chief of their army and navy is the man who holds the power. Merryman's case went to a federal circuit court. Supreme Court Chief Justice Roger B. Taney weighed in by saying, quote, "I do believe Lincoln is grabbing a power which he does not possess under the Constitution. Even the English monarch cannot suspend habeas corpus without approval by Parliament," unquote. Many agreed, but others praised Lincoln for doing what was necessary to defend the Union and constitutional order. This situation sounds similar to what we talked about in the previous video about a person's free speech rights being limited in times of war. In this case, it was about a person having their civil rights limited when they were in prison. But still, are there any problems with habeas corpus? Well, nowadays we face many possible emergencies that did not occur to the framers, such as natural disasters and cyber terrorism. In frightening instances, we might need someone who can make fast, unquestioned decisions, but it's not clear who has the authority to do what. The habeas corpus clause limits the federal government's ability to suspend it in cases of rebellion or invasion. But can an infectious microbe be considered an invasion? And can the president order everyone in the country to stay home? Congress has authorized the president to issue an executive order identifying particular diseases as quarantinable. With that, U.S. law allows the president to order the apprehension, detention, or conditional release of individuals for the purpose of preventing the introduction, transmission, or spread of such communicable diseases. If the president issues this executive order, the CDC's powers to oversee these processes kick in. Furthermore, the CDC uses the Commerce Clause of the Constitution to justify Congress's ability to delegate such authority. Article 1, Section 8 gives Congress the power to regulate commerce with foreign nations among the several states and with the Indian tribes. In the late 18th century, this had nothing to do with emergencies, but the CDC asserted that transporting sick people is no different from transporting washing machines or any other product that crosses borders. The authority to enforce quarantine is among the police powers, which is the protection of the public health, safety, and welfare that states commonly carry out. States cannot violate the U.S. Constitution, but they are given wide latitude in defining such protection, especially in cases of public health emergencies. The CDC asked lawyers and health specialists to draft a set of laws that state legislatures could adopt before another threat loomed. They came up with the Model State Emergency Health Powers Act. It gave states allowance to do things like commandeer private property to cope with an emergency and define public health emergency however they like. Around 40 states have introduced their versions of the act. Both liberals and conservatives have strongly criticized these broad powers that states have given themselves. They thought officials could quarantine people with no justification, and such model laws could turn governors into dictators if they panic. And with each state developing its laws, the country could have too many complex and inconsistent procedures to follow in various places. So we see that the problem is coming from vague guidelines on what counts and does not count as an invasion. As we keep seeing many times before, we left it up for interpretation on using existing powers for the government as a way to broaden their scope on how they handle emergencies, even if it means interfering with people's civil rights. Let's look at an example. In March 2014, officials finally identified the disease that, in the previous 3 months, had killed 59 residents of the West African country of Ghana, the Ebola virus. An illness that can leap from animal to human, Ebola was crossing borders and spreading rapidly. Many were concerned that it would go global. In October 2014, 2 nurses in Texas who had cared for an Ebola patient became infected. President Barack Obama declared Ebola a national security priority. Some members of Congress called for a travel ban between the U.S. and West Africa, and the governors of New York, New Jersey, and Illinois issued a mandate. All healthcare workers who had contact with Ebola patients in West Africa must be quarantined for 21 days upon entering the U.S. The same day on which the mandates were enacted, Casey Hickox, a specialist in tropical nursing, was returning to the U.S. after caring for Ebola patients in Sierra Leone. Following a 2-day return trip, she landed in Newark, New Jersey, and had to quarantine. At the hospital, a doctor took her temperature and it was normal. A technician tested her blood for Ebola and it was negative. Dr. Thomas Frieden, director of the Centers for Disease Control and Prevention, CDC, said, quote, "It is not necessary to quarantine Hickox. She simply needs to check her temperature twice a day for 21 days, unquote." But New Jersey Governor Chris Christie said, quote, "Hickox must remain isolated," unquote. After 2 days of staying in an unheated tent, Hickox hired a civil rights lawyer to argue her case against the state of New Jersey. She felt like her basic human rights had been violated and it was not constitutionally just. The next day, after again testing negative, Christie allowed for Hickox's release on the condition that she proceed directly to her home in Maine. But Paul LePage, Maine's governor, insisted that she remain there for 3 more days and then follow the CDC's guidelines. Hickox said, quote, "I remain appalled by these home quarantine policies that have been forced upon me, even though I am in perfectly good health. I will go to court to fight for my freedom," unquote. But LePage took Hickox to court to enforce the quarantine. She was confined to her home with state police posted outside. After some time, the legal system in Maine ruled in her favor. They said, quote, "The court is fully aware of the misconceptions, misinformation, bad science, and bad information being spread from shore to shore in our country concerning Ebola. The court is fully aware that people are acting out of fear and that this fear is not entirely rational," unquote. Based on this example, you can see how 2 state governments have different instructions on trying to handle Hickox that made her quarantine confinement violate her civil rights, and how there was a lack of coordination with each other. The court affirmed that the continuous attempts at confinement was based on fear that was not entirely rational. Acting on fear is the same as acting on emotions that involve making decisions that might feel safe, even at the expense of someone's civil rights. All of this shows that the U.S. Constitution would serve the country better if it were amended to spell out more clearly the actions that particular federal officials could take in times of crisis. It needs to be clear that we cannot solely leave these types of wide-scale issues up to the states because inconsistencies can arise. In addition, the definition of crisis needs to include more than invasion and rebellion. It should talk about diseases, natural disasters, cyber attacks, and much more. This is so we are acting rationally and have a clear set of guidelines to follow, so everyone in the government is being held accountable. Let's look at some comparisons with other systems of governments on this matter. Although US states can make such model laws, they cannot suspend due process and round people up in times of emergency. But most states do give their governors the power to call out the National Guard under more or many more circumstances than just rebellion or invasion. In 2016, Florida's Governor Rick Scott declared a state of emergency when a mass shooting occurred at an Orlando nightclub. In 2018, the governors of Texas and Arizona deployed troops along the US-Mexico border in support of President Donald Trump's immigration policies. In 2019, Washington Governor Jay Inslee declared an emergency because of a measles outbreak. Other countries have different approaches too. The Constitution of South Africa offers a modern model of emergency powers. Only the national legislature, not the president or the courts, can declare a state of emergency. Parliament can declare a state of emergency only when two conditions are met. One, the life of the nation is threatened. Two, the declaration is necessary to restore peace and order. The courts can still determine whether the emergency is valid and overrule Parliament's declaration and any emergency laws it passes. South Africa's constitution recognizes many kinds of emergencies, including, quote, war, invasion, general insurrection, disorder, natural disaster, or other public emergency. A declared state of emergency can last no more than 21 days. It can be extended by the lower house of Parliament, but only for 3 months at a time. In conclusion, habeas corpus remains one of the most vital protections of freedom in our country. It ensures that no person is unlawfully detained without justification and acts as a powerful check against government overreach. However, as history and modern cases have shown, this right is not absolute. From linking suspension of the writ during the Civil War to the quarantine during the Ebola outbreak, emergencies often test the balance between public safety and personal freedom. The challenge lies in how broadly the term emergency is interpreted. The Constitution limits suspension of habeas corpus to cases of rebellion or invasion, yet new threats like diseases, natural disasters, cyber attacks, etc., are not covered clearly. As a result, federal and state authorities often act based on fear, uncertainty, or inconsistent laws, which lead to violations of civil rights and confusion over who holds the power to act on a specific crisis. The United States Constitution should have a clear framework that explicitly defines the scope of emergency powers and how due process should be followed in handling people's civil rights. That can help bring some accountability to the federal government and prevent them from becoming too overpowered and interfering with our civil rights. In the next video, we will talk about the process of amending the Constitution. Until then, please like this video, subscribe to my YouTube channel, and turn on the post notifications so you will be notified when I post my next video. I appreciate your support. Remember, you are powerful, you are capable, and you are the changemaker our society needs. Thank you so much for watching this video. I will see you soon.